The Senate will please come to order. To begin today, we'll take a moment of silence in lieu of a devotional. Thank you. Are there any announcements? The chair has a brief announcement. Today marks the launch of Lieutenant Governor for a day. We have joining us via YouTube today, Miss Foreman's 5th grade class from the Rutland Intermediate School. All the students are eager to watch today's proceedings, and senators are welcome to invite students to participate in this program. We have 5 bills for introduction today. And before we get to the bills, we also have appointments for announcement, gubernatorial appointments. We have 11 appointments which we have received from the governor and which are now being referred to the committees having jurisdiction. These appointments will appear in today's journal, which you will receive tomorrow. And moving to the bills. S90, an act relating to establishing an amyotrophic lateral sclerosis registry, introduced by Senators Lyons, Terenzini, Campion, Chittenden, Cummings, Hardy, Hooker, and Perchlik. Please listen to the first reading.
S90, an act relating to establishing an amyotrophic lateral sclerosis registry.
You've heard the first reading, and the bill is referred to the Committee on Health and Welfare. S91, an act relating to Parent-Child Center Network, introduced by Senators Westman, Hardy, Hooker, McCormick, and Perchlik. Please listen to the first reading.
S90, an act relating to Parent-Child Center Network.
You've heard the first reading, and the bill is referred to the Committee on Health and Welfare. S92, an act relating to beverages in children's meals, introduced by Senators Clarkson and Hooker. Please listen to the first reading.
S92, an act relating to beverages in children's meals.
You've heard the first reading, and the bill is referred to the Committee on Health and Welfare. S93, an act relating to exempting certain services from the requirements for unemployment insurance and workers' compensation coverage, introduced by Senator Sears. Please listen to the first reading.
S93, an act relating to exempting certain services from the requirements for unemployment insurance and workers' compensation coverage.
You've heard the first reading, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. S94, an act relating to the cannabis excise tax and local fees, introduced by Senator White. Please listen to the first reading.
S94, an act relating to the cannabis excise tax and local fees.
You've heard the first reading, and the bill is referred to the Committee on Finance. And finally, S95, an act relating to government accountability and state quality of life outcomes, introduced by Senators Collmore and White. Please listen to the first reading.
S95, an act relating to government accountability and state quality of life outcomes.
You've heard the first reading, and the bill is referred to the Committee on Government Operations. This brings us to the orders of the day. We have on the calendar for third reading, S86, an act relating to miscellaneous changes to laws related to vehicles and vessels. Are there any amendments before third reading? Please listen to the third reading of the bill.
S86, an act relating to miscellaneous changes to laws related to vehicles and vessels.
The question is, shall the bill pass? Are you ready for the question? And if so, please unmute. All those in favor signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've passed S86. We also have for third reading today, S87, an act relating to emergency provisions, for the operation of government. Are there any amendments before third reading? Are you ready for the question?
Third reading.
First, we'll have third reading.
S87, an act relating to emergency provisions for the operation of government.
Are you ready for the question? Oops, Senator Collmore is recognized.
Thank you, Madam President. Yesterday, there was a request by one of my colleagues from the Chittenden District to provide a bit more clarity with regard to how these emergency provisions would work. Each of the emergency powers is automatically triggered only by a declared state of emergency. However, each piece does require some action by the state or local officer who oversees the relevant program or operation. So, for example, sections 2 and 3 have to do with grand list inspections, and it is in the discretion of the BCA or the Department of Taxes hearing officer to determine whether in-person inspections should be suspended. The property owner retains the right to demand an electronic inspection. Section 5 has to do with the extension of municipal deadlines and licenses. Again, it is in the discretion of the municipality as to whether a deadline may be postponed or a license extended. Section 7 has to do with the extension of professional license terms. This would be at the discretion of the director of OPR. Sections 8 and 9 have to do with out-of-state and inactive healthcare professionals, again, at the discretion of the director of OPR in consultation with the Commissioner of Health. Section 10, the authority to act for boards is at the discretion of the OPR director, provided that the director does find that a board cannot meet or operate safely. Section 11 has to do with emergency regulatory orders and is at the discretion of the director of OPR. Sections 12 through 14 have to do with the Board of Medical Practice, the orders, out-of-state and inactive medical practitioners. This would be at the discretion of the executive director of the Board of Medical Practice, if authorized by the Commissioner of Health. And the final section had to do with emergency sheriff funding. That would be subject to approval of the county judges. Thank you, Madam President.
Thank you, Senator. The question is, shall the bill pass? Are you ready for the question? So please unmute. All those in favor signify by saying aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and you've passed S87. We have on the calendar for action S45, introduced on January 26, 2021. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends the bill be amended as appears on pages 142 to 146 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S45.
S45, an act relating to earned discharge from probation.
The chair recognizes the senator from Bennington, Senator Sears, for the report of the Committee on Judiciary.
Thank you, Madam President. I appreciate it. Among the documents that I would have handed out on your desks where we're meeting in Montpelier is a report from the Pew Charitable Trust, December 2020. States can shorten probation and protect public safety. This came out just at about the same time that your Justice Reinvestment 2 working group was finalizing its recommendations for legislation and administration to work on justice reinvestment. One of the things that I found in that report, and it's a startling fact, 1 in 72 adults in the United States are on probation. 1 in 72. You think about those numbers, and Vermont may be more or less, but 1 in 72 is certainly a high number. And this article is full of information about how different states deal with probation. First of all, I probably ought to describe what is justice reinvestment for those of you who are new to this chamber or new to the legislature. Justice reinvestment is a data-driven approach to improve public safety, reduce corrections and related criminal justice spending, and reinvest those savings so that we can decrease crime and reduce recidivism. It also helps to change lives. In 2007, Vermont had one of the fastest growing prison populations in the nation, along with Idaho. And that led the legislature, the governor, and the Chief Justice of the Supreme Court at the time to call together the branches of government to work with the Council of States Government Justice Center on our initial justice reinvestment. If I might quote from former Governor Douglas, Madam President.
Senator, do you mind repeating the request?
May I quote from former Governor Jim Douglas?
Without objection, you may.
Thank you. High rates of recidivism come at substantial cost to taxpayers and create unsustainable growth in our state corrections budget. We need to continue to identify and implement new strategies that will protect our families and the safety of our communities by focusing on successfully reintegrating property and drug offenders into the community and preserving prison beds for the most serious offenders. And that really was the impetus of justice reinvestment. We continued to reduce those beds. We had at that time about 750 out-of-state prisoners. Today, that number is down below 200. And if you do the math and you assume that it costs $30,000 a year to house somebody out of state, the state of Vermont is saving $16,500,000 a year. That's a sizable number. If all of that money were reinvested into justice reinvestment programs, that would be extremely helpful. Unfortunately, it's not all reinvested, and your Appropriations Committee last year tried to set fences around the use of that money and those savings. In 2019, the Justice Center Working Group recommended Vermont reform its probation discharge process as part of the Justice Reinvestment 2 report. Unfortunately, the stakeholders could not agree on how to move forward with the policy to release probationers from their term of probation if they no longer posed a risk to public safety. This bill reflects the compromise reached by the stakeholders for a process to presumptively release probationers at the midpoint of their probation term if they do not pose a risk to the community or to the victim. Studies have shown that most individuals who are on probation will mess up within the first 12 months of that probation, actually a higher percentage in the first 7 months. So folks who are successful for the first year or so of probation should be considered for discharge. And Vermont has a midpoint review process that this bill tries to use as a requirement now to look at the midpoint review and consider that person for discharge. So Section 1 of the bill adds a section of law to the beginning of the probation chapter. It states that the policy of the state with respect to probation provides the purpose to rehabilitate offenders, reduce the risk that they will commit subsequent offenses, and protect the victim and the community. Excuse me. Section 2 amends the law that requires the sentencing court to discharge a person from probation if the Department of Corrections files a motion to discharge them and certain criteria are met. Section 3 amends the law that requires the Department of Corrections to review probationers at the midpoint of the probation term and file a motion to discharge them if certain criteria are met. Since the department review occurs first in the chronological order, I will summarize Section 3 and then Section 2, though the explanation of events makes more sense. So Section 3, subsection D of this section requires the Commissioner of Corrections to review the record of each probationer serving a specified term of probation during the month prior to the midpoint of the probationer's term. So if the probationer is serving a 2-year probation term, at the 11th month, the commissioner would review that. If the probationer meets the criteria outlined in A, B, and C, the commissioner shall, and I emphasize shall, file a motion requesting the court discharge the remainder of the probation term. In order to be eligible for the midpoint discharge, the probationer must not be adjudicated in violation of conditions of their probation within the previous 6 months, not be serving a probation sentence for certain crimes, including crimes of sexual assault, domestic assault, lewd and lascivious conduct with a child, and have completed any rehabilitative or risk reduction services, the duration of which are set and knowable at the outside of probation that are required as a condition of probation. Now, I will use an example of a DUI case where they're required to go to crash and required to participate in the program. They might also find that this individual has a significant substance abuse problem during that process. But obviously, you wouldn't keep them on probation since recovery is a lifetime event. You would not keep them on probation for the rest of their lives. But you would not be able to be released if you hadn't completed the crash program. So those are, you knew at the beginning of the probation you had to participate in the crash program. Subdivision D2 provides the probation, if the probationer fails to meet those criteria, then the commissioner must file a motion to discharge the probation term once the probationer does meet the criteria. So if for whatever reason they haven't completed that term of harm reduction or programming, once they have completed that programming, the probation, the commissioner must file a motion to dismiss, to discharge from probation. Subdivision D3 requires the prosecutor make a reasonable effort to notify any victim of records about any potential reduction of the probationer's term as a result of the midpoint review. It defines a reasonable effort as attempting to contact the victim by first-class mail at the victim's last known address and by telephone at the victim's last known phone number. Now going back to Section 2, this section directs the court to presumptively terminate the probation term if the commissioner files a motion to discharge at the midpoint review. However, it does provide that the court till discharge unless the prosecutor seeks to continue the probation term and one of the following criteria are met. The court finds by a preponderance of the evidence that termination and discharge will present a risk of danger to the victim of the offense or to the community. The committee spent quite a bit of time on the standard by which you would determine whether or not a person would be discharged. We landed upon the preponderance of the evidence, which is sort of a midpoint to make sure that the person is no longer a risk of danger to the victim of the offense or to the community. I think we're erring on the side of caution there with preponderance of the evidence. B, the court finds by clear and convincing evidence that the probationer is not substantially in compliance with conditions of probation that are related to the probationer's rehabilitation or to victim or community safety. So that is a higher standard of evidence to get to that point. B2, gives the court the discretion to continue probation for a full term or a shorter term, and it grants the prosecutor's motion to continue the term, if it grants the prosecutor's motion to continue the term. It also requires the court to review the conditions and eliminate any unnecessary conditions for the remaining probation term. So this allows the Department of Corrections basically to review some of the terms of the probation and conditions of probation and remove those that are no longer applicable. C provides that probationers are eligible for discharge at the midpoint review, even if they have unpaid restitution fees or surcharges. Section 5 directs the Sentencing Commission to review the Pew Charitable Trust report and consider whether Vermont should limit the duration of the misdemeanor probation terms to 2 years. Currently, probation terms for misdemeanors are not capped at 2 years. It directs the Commission to make that report available. Date of that to the Justice Oversight Committee in October of this year. This bill would take effect on July 1, 2021. The committee vote was 5-0-0 in support of the bill, and we urge the Senate to approve the legislation.
Thank you, Senator. The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary?
Madam President, may I interrogate the reporter of the bill?
Senator, you may.
Thank you. Madam President, my question is just about the data section. I see a lot of requests for information, and as we've noted many times in previous legislation, there's often room for discretion around issues like race and gender. And I just wonder if the committee heard testimony or is considering disaggregating the information about the data collected by race and gender.
The committee, as well as the working group on justice reinvestment, heard an awful lot of information about data and the collection of that data. I would expect that that will be part of another bill that will be coming shortly. I believe the House is taking the lead on, where we have recommendations from the RDAP panel on data collection on the adult and juvenile justice systems. But we didn't take specific data, for example, on the number of probationers. We didn't get specific testimony on the data regarding the probationers in Vermont during the formulation of this bill.
Thank you, Madam President. I would say as long as we are looking at any point in the judicial system where there's discretion and disaggregating the information by race and gender, I am satisfied. Thank you.
Madam President, I appreciate the question, and I also would point out that one of the things we're trying to do is to make things a little more not so much geographic justice in the state, so that one county is different from another. And that's one of the reasons for the study on having a 2-year cap on misdemeanor probation, so that there's no reason why somebody would get 1 year in Chittenden County and 5 years in Rutland County for the same offense.
Madam President, I very much appreciate the thrust and spirit of the bill, and that ends my interrogation.
Thank you. Senators are kindly reminded that although we're in virtual session, that there is no technology within the virtual session, cell phones included. Are there any additional questions before we move to the question? The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? And if so, please unmute. All those in favor signify by saying aye.
Aye.
Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it. And you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for the question? The senator from Windham is recognized.
Thank you, Madam President. I want to thank the Committee on Judiciary. As I was thinking about this bill, the importance of this bill, I was reminded of something I'm sure many senators remember. There was a documentary that was first recorded back in 1978 called Scared Straight. And the conventional wisdom was you could bring young people to prisons, have them interact with hardened criminals, and that they would be so moved by the experience that they would straighten up and fly right. And the conventional wisdom was this was the way to interact with folks that we today would call at risk. Now, of course, the conventional wisdom was completely wrong. What we realized was folks that participated in that program were actually more likely to become incarcerated. And so this is another example of us needing to re-examine things that we held so true for so long, which is the longer that you keep somebody on probation, the longer you keep them within the criminal justice system, the more likely you are to keep your community safe. And we know, in fact, that that is not true. So I want to thank the Chair of Judiciary for continuing to do this very important work on Justice Reinvestment 2. It helps not just individuals, it helps communities. Thank you.
Thank you. The question is, shall the bill be read the third time? Are you ready for the question? And if so, please unmute. All those in favor signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of S45. We will now take up SR8, which was placed in the calendar for action today. This resolution has been read already and is set forth in yesterday's journal, which is about, which you have. The question is, shall the Senate adopt the resolution? The Senate resolution relating to temporary Rule 44A. Are you ready for the question? And if so, please unmute. All those in favor signify by saying aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and you've adopted SR8. This completes the orders of the day. The senator from Windham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until Thursday, February 25th at 1 p.m.
The senator from Windham has moved that subject to any announcements, the Senate do adjourn until Thursday, February 25th at 1 p.m. Are there any announcements? The senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet 10 minutes after the fall of the gavel.
The senator from Windham is recognized.
Thank you, Madam President. Senate Government Operations will meet 10 minutes after the fall of the gavel.
Thank you. The senator from Caledonia, the junior senator, is recognized.
Thank you, Madam President. Institutions will meet 5 minutes after the fall of the gavel.
Thank you. The senior senator from Caledonia is recognized.
Thank you, Madam President. Senate Appropriations will meet at the fall of the gavel. Thank you.
Thank you. The senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet at 1:45.
Thank you. Are there any additional announcements? Senator from Addison is recognized.
Senate Natural Resources and Energy meets tomorrow morning at 9 a.m.
Thank you, Senator. Seeing no further announcements, the senator from Windham has moved that the Senate adjourn until Thursday, February 25th at 1 p.m. Are you ready for the question? So please unmute. All those in favor signify by saying aye.
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 Those opposed, nay. The ayes have it, and the Senate stands adjourned until Thursday, February 25th at 1 p.m.